Starting today, there is a ban on semi-automatic weapons.
Series of new gun control measures.
New gun safety legislation. That bill is called the
Protect Illinois Communities Act.
We will see you in court.
Most people think the hardest part about owning a gun in Illinois is buying one. They're wrong. The hardest part is everything that comes after, and if you're anywhere near Chicago, the margin for error shrinks to almost nothing. Illinois has layers upon layers of rules that trip up even experienced gun owners, and by the time we get to the end of this, you'll understand exactly why one wrong turn, one unplanned stop, one block festival you didn't know about can turn a legal carrier into someone having the worst day of their life. So let's break down every single thing you need to know, starting with the foundation. First things first, Illinois is not a permitless carry state. You cannot just strap on a holster and walk out the door. Open carry is generally off the table too. If you want to carry a handgun in public legally, you need an Illinois concealed carry license, commonly referred to as a CCL. Getting that license isn't a quick process either. For most applicants, it requires 16 hours of state-approved training plus a live fire range qualification. You have to be 21 years of age or older, and you need to pass the background check that comes with it. But here's where Illinois starts to separate itself from most other states. Before you even think about a CCL, before you even think about buying a gun or a single round of ammunition, Illinois requires something called a firearm owner's identification card. You'll hear it called a FOID. This card is essentially your permission slip from the state to possess firearms and ammunition in most circumstances. Without it, you're not legally in the game. The FOID has its own set of rules and its own age requirements. If you're under 21, you're going to need a parent or legal guardian to sign off on your application unless you qualify through military service. Now here's the part that catches a lot of people off guard, especially if they haven't been paying close attention to what's changed recently. Illinois passed a law that goes by the name PICA, which stands for the Protect Illinois Communities Act. This legislation significantly tightened what residents can buy, sell, and even possess when it comes to certain firearms the state classifies under the assault weapon umbrella, along with specific parts and accessories. It also restricts what the law calls large capacity ammunition feeding devices. For handguns, that threshold is magazines holding more than 15 rounds. For rifles, it drops to 10. There are certain narrow exceptions, but the general rule is clear. If you're buying new magazines or firearms in Illinois, you need to know exactly what PICA allows and what it doesn't, because getting this wrong has real consequences, and all of that is just the starting point. The next part is where people actually get burned in real life. This is the section that generates more questions, more mistakes, and more legal problems than almost anything else in Illinois gun law. Let's walk through it carefully. If you hold an Illinois CCL, you can keep a concealed handgun in your vehicle, and it can be loaded. That's your legal lane as a concealed carry license holder. But if you only have a FOID and no CCL, everything changes. In that case, your firearm must be unloaded. It has to be enclosed in a case, placed in a container, broken down into a non-functional state, or stored in a way that makes it not immediately accessible. You don't get to have a loaded handgun sitting in your center console with just a FOID card. Long guns add another layer. Whether you have a CCL or just a FOID, rifles and shotguns in a vehicle must be unloaded and enclosed in a case. No exceptions on that one. Now let's talk about traffic stops, because this comes up constantly. Illinois is not a state where you're automatically required to inform an officer that you're carrying the moment they walk up to your window. However, and this is critical, if the officer asks whether you're armed or asks to see identification related to carrying, you are legally required to disclose that you have a firearm and present your CCL. You need to tell them where the gun is located, and the officer has the authority to secure your weapon for the duration of the stop. This can apply to passengers in the vehicle as well, not just the driver. Here's something that non-residents need to pay very close attention to. If you're from another state and you're legally permitted to carry under your home state's laws, Illinois provides what amounts to a vehicle-only pass. You can carry concealed inside your vehicle while passing through Illinois, but the moment your feet hit the pavement, that protection vanishes. You step out of the car, you're no longer covered, and this vehicle-only provision does not override any of the prohibited location rules. If you park near a restricted area, your only legal move is to secure the firearm in a locked case inside a locked vehicle or in a locked container out of plain view before you go anywhere. This is the trap that gets people who think having a CCL means they can carry everywhere. It doesn't. Illinois has a long and very specific list of places where carrying is completely off limits, regardless of your license status. Let's walk through a normal day and see how fast the restrictions pile up. You start your morning with school drop-off. Every K through 12 school is a prohibited zone, and that means the building and the surrounding property. Preschools and childcare facilities fall under the same restriction. The only legal option for a CCL holder in this scenario is to keep the firearm secured in the vehicle. You stay in the car for the pickup line, you do not step out while armed, and you move on. Next, maybe you have business on a college campus. Universities and colleges are off limits too. This is where a surprising number of people get caught because they convince themselves that running in for 30 seconds doesn't count. It counts. Every time. Midday hits and your schedule shifts. Courthouses are an absolute hard stop. Government buildings tied to executive or legislative functions are restricted. Jails and prisons aren't gray areas, they're completely off the table. Then something unplanned comes up. You need to visit a mental health facility or a nursing home. Both are prohibited. Need to hop on public transit to get across town. The train and the bus are red zones in Illinois. Your concealed carry license does not travel with you onto public transportation. Evening rolls around and you head out for dinner. If the establishment earns more than half of its revenue from alcohol sales, you cannot carry there. That line between a restaurant that serves drinks and a bar that serves food matters enormously in Illinois, and getting it wrong is entirely on you. You decide to take a walk afterward. Public playgrounds, parks, and athletic areas operated by park districts are all prohibited zones. There is a carve-out for trails and bikeways, even if the path technically runs through a park, but the general park property itself remains restricted. And then there's the big crowd category. Casinos, gaming facilities, horse racing venues, sporting events, amusement parks, concerts, festivals, zoos, and museums are all on the no-carry list. Airports are a hard red zone, not just at the terminal, but across airport-controlled property. One more thing about signage, because people misunderstand this constantly. Illinois has a standardized no firearms sign that serves as legal notice. Private property owners can post that sign and ban carrying on their premises. But here's the key distinction. If a location is prohibited by statute, the absence of a sign does not make it legal. The law applies whether someone remembered to put up a sign or not. And if you're ever asked to leave a location by someone with authority over that property, you leave. You don't debate, you don't argue, you comply and walk away. That is always your best legal move. So you've got your FOID sorted out and you walk into a gun store ready to make a purchase. You'll fill out ATF Form 4473 just like you would in any other state. But the background check process in Illinois runs through the state police's own system called FTIP, which serves as the gateway into the federal database. At the counter, the dealer will get one of three results. Approved means the transfer is cleared and will receive a state police approval number. Delayed means the system hasn't made a determination yet and you're in a holding pattern. Denied means the transfer is stopped completely. But even if you get an immediate approval, you're not walking out the door with your new firearm that day. Illinois imposes a 72-hour waiting period from the time the sale is initiated before the dealer can release the gun to you. 72 hours. No exceptions at the retail level. If you get denied and you believe it's a mistake, you'll need to obtain the denial transaction number from the dealer and work through the Illinois State Police appeal process. It's not quick, it's not simple, but it is available. Private sales between individuals aren't any easier. Before transferring a firearm to another person, the seller must verify the buyer's FOID through the Illinois State Police online transfer portal and receive an approval number. The 72-hour waiting period still applies to private transfers, and the transfer record must be submitted and retained as required under Illinois law. There is no handshake deal, no parking lot exchange without paperwork. The state tracks it. If you fall into a prohibited category, there's no workaround, no partial exception, and no gray area. The standard federal prohibitions apply, including felony convictions, domestic violence convictions, active orders of protection that bar firearm possession, certain mental health adjudications, and drug-related disqualifications. But Illinois adds its own enforcement teeth that go beyond what most states do. If your FOID card gets revoked, you have 48 hours after receiving notice to surrender the card and file what's called a firearm disposition record. That document requires you to account for where every firearm you own is going. You can transfer them to someone who holds a valid FOID, temporarily surrender them to a licensed dealer, or turn them over to law enforcement under the provisions the law allows. If you ignore this requirement or try to wait it out, law enforcement can petition the court for a warrant to seize both your FOID card and your firearms. And the Illinois State Police continuously monitors state and federal prohibitor databases against the list of active license holders. This isn't a one-time background check at the point of purchase. It's ongoing surveillance of your legal status for as long as you hold that card. Now we get to the part that makes everything above feel simple by comparison. Technically, Illinois state law prevents Chicago from creating its own separate handgun carry rules for CCL holders. The preemption exists on paper, but the reality of carrying in Chicago is an entirely different experience than carrying anywhere else in the state. The city's posture toward firearms is aggressive and getting more so. Chicago has filed litigation against a major firearm manufacturer, arguing that certain pistol models are too easily converted using illegal modification devices. The city is actively seeking court orders to restrict the sale and marketing of those specific models. That case has already survived early attempts to throw it out and is moving forward through the courts. That alone should tell you everything you need to know about how city leadership views civilian gun ownership. But here's the landmine that nobody sees coming until they're standing on top of it. The landscape around you in Chicago can change without any warning whatsoever. Illinois law prohibits carrying at any permitted public event held on public property. In a city like Chicago, that can mean a street festival, a block party, a neighborhood market, or a cultural event that materialized on your street overnight. You park where you always park, you step out of your car the way you do every single day, and suddenly you're standing in a prohibited zone that didn't exist yesterday. That is the Chicago trap in its purest form. The statewide rules don't change. The prohibited locations list doesn't change. But the density of the city, the frequency of public events, and the enforcement environment mean your margin for error is razor thin. One wrong step, one assumption that today is the same as yesterday, and you've crossed a line you didn't even see. This is why carrying in Illinois, and especially in Chicago, demands a level of daily awareness that goes far beyond just having the right license in your wallet. You have to know the rules, yes, but you also have to be constantly reading your environment, checking for posted signs, watching for event barricades, and making decisions in real time about whether the space you're about to enter is still a legal place for you to be armed. That's it for today, folks. See you in the next video.